I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. One day this week, I began my column on the ABI website by saying, beware of consent orders. My admonition was based upon a new decision from the Fifth Circuit Court of Appeals in New Orleans. Here's what happened. In bankruptcy court, two third-party non-debtors were in disputes with one another, and they agreed to modify the automatic stay so they could continue their fights in a state court. In that negotiated consent order, the two third parties said, in substance, that one of the third parties, under no circumstances, could make claims against the other third party. So the bankruptcy judge signed and approved that negotiated consent order. The two third parties went about their merry way in discovery in the state court, and lo and behold, one of the third parties learned that in fact it had major claims against the other third party, and therefore tried to amend the complaint in the state court to assert those new claims. Well, you can guess what happened. The other third party went back to the bankruptcy court and said no. The consent order said that you'd make no claims under any circumstances. And the bankruptcy judge agreed, said, nope, you can't pursue those claims in state court. District court affirmed, goes to the circuit. And here's what was really interesting in the decision by Circuit Judge Patrick Higginbotham, affirming bankruptcy judge Harlan Hale from Dallas. Judge Higginbotham said that consent orders are like contracts, and therefore they should be interpreted like contracts. He went on to say that because we're looking at it like a contract, we are going to interpret that consent order according to its very plain terms. And its plain terms said that the one third party could not sue the other under any circumstances. Well, I hazard to guess that if a bankruptcy court had written the order, let's say on its own at the end of a big litigation, the bankruptcy court under those circumstances might have said, well, my choice of words in that order was not really what I intended, so I'm going to let you sue. But it wasn't an order written by the judge, and it did not involve the judge's, shall we say, subjective intent. Judge Higginbotham said, we interpret consent orders strictly according to their terms. So I guess that's good reason for an admonition. If you're writing a consent order, be very sure that you can live by its terms no matter what developments might be in the future that you could not contemplate. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well. Good day.